All right, let's read about Virginia stuff really quick because I'm very curious about this whole Virginia defamation shit. In the wake of the recent 6-week-long trial and defamation verdict in favor of Johnny Depp in Virginia Fairfax County Circuit Court, many are asking, what led to this outcome? Holland and Knight litigators share 3 facts. Okay. Number 1, Virginia's weak anti-slap law. There has been a widespread speculation that in Depp v. Heard, Depp's attorney maneuvered his defamation case through Virginia State Court in order to take advantage of Virginia's relatively weak anti-slap legislation. But what is exactly an anti-slap law, and how does Virginia benefit defamation plaintiffs? Did I just read that right? How does Virginia's benefit defamation plaintiffs? Okay, that sentence is just weird, okay? Not me. SLAP stands for Strategic Lawsuit Against Public Participation. These are commonly understood as to be meritless defamation and other tort claims filed to retaliate against and silence critics, usually consumers, activists, or journalists who speak out negatively against them. Oftentimes, the specter of the protracted litigation, the associated exorbitant costs are enough to cow a party's critics into silence, even though the threatened lawsuits lack merit. In order to combat SLAP's chilling effect on the First Amendment's right, 32 states and the District of Columbia have passed anti-SLAP legislation to discourage the filing of SLAP suits. So that's good. Most states' anti-SLAP laws provide defendants a way to seek a quick and inexpensive dismissal of a defamation case before discovery begins. For example, California, where Depp and his ex-wife Amber Heard resides and have more connections than Virginia. See, I honestly do think that the reason why they brought the lawsuit to Virginia was because of the weak anti-SLAP law. You know how they're like, because, there's like servers here in Washington Post. I think that was just like an excuse. But I think the main reason, a very strategic reason, is because Virginia has a very weak anti-SLAP law, and it's more favorable towards the plaintiff. For example, California, where Depp and Heard resided, provides the SLAP defendants may invoke anti-SLAP immunity and file a motion to strike a complaint within 60 days of service. Yeah, I think that's what Amber Heard tried to do. They tried to invoke the anti-SLAP immunity, and that was denied. After some high-profile defamation suits that were filed in Virginia, including Depp v. Heard and Nunes v. Twitter, the Virginia General Assembly amended the Commonwealth's anti-SLAP statute. The amendment grants immunity from defamation claims to persons who speak out on a matter of public concern to either a third party or governing body, so as long as the statements are not made with the knowledge or reckless disregard of their falsity. Even after this amendment, however, Virginia's anti-SLAP law lacks any defined procedure for defendants to challenge SLAPs and resolve questions of immunity in the pleading or pre-trial stages of the case. Instead, the defendant in Virginia may raise anti-SLAP immunity only as a defense to the jury at trial. Consequently, the defendant in the defamation suit in Virginia faces significantly more economic risk than defendants in other jurisdictions because he or she must take on the cost of litigating the case through trial in order to eventually even substantively argue an anti-SLAP defense. So, totally makes sense why Amber Heard and her team did not want to litigate in Virginia. They wanted to do it in California. I did want to look at a case that Ben Chu kept referring to in regards to defamation. It was mentioned somewhere around here. I thought I saw it somewhere. Just because you told the truth doesn't mean you didn't slander someone. So very interesting headline article right there. But what does it mean? What does that mean right there? Larry received a good bit of publicity recently over his slogan, "Just because you did it doesn't mean you're guilty," as shown below on a North Carolina billboard. Yesterday, the Virginia Supreme Court issued a ruling that stands for a similarly counterintuitive proposition. Despite the widespread notion that truth is a complete defense to defamation claims, you can't always escape liability for slander, even if everything you said was literally true. Now, what does that mean? Even where the words, when read out of context, are literally true and defamatory meaning is not immediately apparent, Virginia law permits the plaintiff to maintain an action for defamation where innuendo will lead to a reasonable reader to infer a defamatory meaning. In the case of Pendleton v. Newsome, involves a heartbreaking story of a 7-year-old child with a severe peanut allergy who ingested peanut at school and died. Accordingly to the allegations in the complaint, the child's mother, Laura Pendleton, had informed the school staff earlier in the school year about her daughter's severe allergy to peanuts and that she provided the school with specific instructions signed by the child's pediatrician about how to treat her daughter in the event of an emergency, and she bought in an EpiPen Jr. Oh my gosh, that is so heartbreaking. I've definitely had friends that were allergic to peanuts. Like I've definitely seen like some cases before. I remember this one time in lunchtime, Somebody was eating a peanut butter sandwich, and the person that was allergic to peanuts had like a reaction just from smelling it. And they had to call in an ambulance, and it was like a whole thing. And ever since then, they banned us from eating like peanut products at school because like this just the smell of it would trigger the allergy, which is really fucking wild. Like holy shit. I feel so bad for parents that have children, and I feel bad for the child too, obviously, that have like these severe allergies and stuff. Like I would be so fucking paranoid over everything. It'd be hard to like enjoy a meal at a restaurant, especially because I would just be really fucking paranoid. Yeah. So this case is like super fucking sad. For the school, so she brought an EpiPen Junior for the school to keep on hand to inject epinephrine if needed. She alleges she was told by the school's clinic assistant that they already had the equipment they needed and didn't need the EpiPen. When the child died and the story received widespread publicity, several school officials gave statements to the press that deflected responsibility and emphasized the importance of parental responsibility, like this one allegedly issued by the school superintendent, Marcus J. Newsome. Oh, so that's who Newsome is. So this is what they wrote. Student and staff safety is a top priority. Earlier this week, a first grade student at Hopkins Elementary School died. Chesterfield County Public Schools is deeply saddened by the loss of this child and has reached out to her family. Key, is a parent's responsibility to provide the school with accurate, timely information, a health emergency plan, and the medicine necessary to execute the plan. If any one of these items is missing, the doctor's orders cannot be carried out. The school, relies on parents to follow through. So what they're saying here, just because you told the truth doesn't mean you didn't slander someone. So everything that the superintendent is saying right here is true. It's like, okay, so parents, it's a parent's responsibility to provide the school with accurate, timely information, emergency health plan, medicine necessary to execute the plan. If one of these is missing, the doctor's orders cannot be carried out. The school relies on parents to follow through. So like all this right here is factually true. And when taken out of context, it is true. However, within the context, when you read an article like this, what does it sound like? Well, it sounds like, oh, wait a second. So it's actually the parents' fault, not the student's fault. It seems like because of this that's written out here, it seems like, oh, the parent probably didn't provide the school with accurate information and it was untimely. And that maybe the parent didn't have an emergency health plan. And maybe the parent didn't do this. Maybe the parent didn't do that. Because like when I read this, that's what I'm reading. That's what I'm hearing. Yeah, so like, oh, like the parent didn't do any of this and that's why the kid died. So who we're going to place the blame on? We're going to place the blame on the parent, not the school. Miss Pendleton sued for defamation, arguing that although the statements may be literally true when read in isolation, the circumstances surrounding the statement and the context in which they made evidence a malicious intent to divert public indignation from the school's failures by falsely implying and insinuating that Miss Pendleton had failed to inform the school authorities of the child's allergy, failed to furnish a doctor-approved emergency medical plan, failed to furnish school. Sorry, I didn't know they were going to go over this again. I think I skimmed over this article. And failed to furnish the school clinic with the required medications for use in such emergency. The trial court thought this was too much of a stretch and dismissed the case. So the case was dismissed. They were like, nope, this is not defamation right here. However, they took it to Supreme Court, and Supreme Court was like, nope. Just because out of context, everything you say is true. However, you have to take within context of things, and this does insinuate that it was the mother of the child that was negligent. Because you know what happened after when they kept going out and publishing these statements? It was not just one statement that they published. It was multiple statements. It was like, I think this goes over the statements that were published, right? Yeah, I think it's somewhere around here. It was not just one statement. It was like more than 5 statements, if I remember correctly. And you know what happened? The mother of the child who passed away, she started receiving like hate. She was receiving hate from her, I don't know if it was like colleagues, other mothers at the school, and they were targeting her and saying that like, oh, she was the one that was not, she was negligent basically. And she's like, bro, what the fuck? Like I'm basically a grieving mother and I'm getting all this hate, and the schools, all they're trying to do is just protect their own ass. So this is what happened in, one of the worst things that could happen to you in your life is having to bury your own fucking child. Like that's something that you shouldn't be doing. Like your child should be burying you, right? And just imagine going through this like awful fucking tragedy, and not just like a older child, it's a young child. So the child didn't even have a chance to like experience like everything in life, like being a teenager, being an adult, going to college, and all that stuff. You know, they're basically robbed of their life at a very young age. And you're dealing with that. And then on top of that, you're dealing with like people's hate, the public hate, and all that stuff. Like, I don't know, it's just really gross and it's just really fucking sad. I can't imagine just having all that piled onto you at the same fucking time. But when the child died, the story received widespread publicity. Several school officials gave statements to the press that deflected responsibility and emphasized the importance of parental responsibility. Like this one allegedly issued by the superintendent, blah, 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 blah. Wait, did I already read that? Sorry, I already read that. I did, right? Okay. Because it was not just the superintendent that made a statement. It was like the school nurse and some other people that worked for the school. In cases of implied defamation, so the reason why we're talking about this as well is because, so this is why this case kept getting reference to, because Ben Chu was just like, oh, you know, if you look at Pendleton v. Newsom, it's it's defamation by implication. So although Amber Heard didn't name Johnny Depp in the Washington Post article, it is implied. And why is it implied? Was because people knew that she was married to him. She also mentioned 2 years. Was it 2 years? Right? Happened in 2016. She wrote the op-ed in 2018, right? She's like, 2 years ago, I was a representative of blah, 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 blah. So that definitely implies that, oh, your relationship with Johnny Depp. So that's why, in my opinion, that's why their case was pretty fucking rock solid. So even though she didn't name Johnny Depp, she still implied that it was him, especially saying 2 years ago. And we all knew in 2016 was when she had the TRO filed. So in the case of implied defamation, context plays a vital role. The court held that if defamatory meaning is not apparent from the literal reading of the statement, stating a valid claim requires a demonstration that a circumstance surrounding the making and publication of the statement could reasonably make the statement to convey defamatory meaning to a reasonable reader. Allegation that such circumstances attending the making of a statement with the explanation of the circumstances and the defamatory meaning allegedly conveyed will suffice to survive demurrer if the court, in the exercise of its gatekeeping function, deemed the alleged meaning to be defamatory. Demur. A pleading that while it may be accepted that facts or evidence may be true, it is denied that the case is relevant or valid. Now, often a motion to dismiss. So this was a decision in June 4. So yeah, initially her case was dismissed, but then it went to Supreme Court of Virginia, and they're like, nope. So on January 12th, Amara Denise Johnson was a 7-year-old first grade student at Hopkins Elementary School in Chesterfield County. Amaria died at the school that resulted in a severe allergic reaction to a peanut provided to her by a classmate. Amara's mother, Laura Mary Beth Pendleton, brought this action in the Circuit Court of City of Richmond against 6 defendants, a superintendent, assistant director of community relations, public health nurse supervisor, director of community relations, assistant superintendent, the chair of the Chesterfield County School Board. The plaintiff was also a licensed practical nurse. She had informed the school staff. Oh, so the mother was a nurse. She informed the school staff early in the school year that Amari was severely allergic to a certain food producing products, including peanuts. She had like emergency plan. We talked about that. On January 2nd, 2012, Amari reported bumps and scratching in her neck, reportedly or shortly after ingesting the peanut, but was not giving Benadryl or epinephrine. Why? Wouldn't the teacher or even the school nurse be like, oh, you know, if you have scratches or if you have like bumps and stuff like that, wouldn't they just be like, oh, you know, maybe it's like an allergy and like, I don't know, like it's really fucking weird. So like after she had these bumps and these scratches, what did they do? Did they just like not sink on their toes and they're just like, oh, okay, like it's not an allergic reaction? The tragic death of the child received prompt and widespread publicity in news reports published by local, national, and international media. The gravamen of the plaintiff's claim is that the statements were maliciously designed to divert public indignation from the failures of CCPS and CCHD. In the following days following Amaria's death, where Ms. Pendleton was seeking answers to and grieving from the loss of her daughter, the defendants undertook a public relations smear campaign to deflect from the schools and health officials. Yeah, I don't know. That is just like so sad. It's like they're just worried about covering up their own ass and just not taking responsibility. So these are the statements. So let's see. Yeah, so we have emails right here, a news article, grieving mom, school knew about peanut allergy. And this article right here, 2 more articles, another article, 2 articles, email response. So it's not just like they made a statement on one article, one email. It was just like she was just getting piled by all these articles and all the statements that they were making in these articles. The family of a Chesterfield girl who died after she suffered an allergic reaction when she ate a peanut at Hopkins Elementary School has settled its wrongful death lawsuit against the state for $662,500. Mara Johnston's family sued the state when the 7-year-old girl died after a classmate gave her a peanut at school. As part of the settlement, no one from the school system admitted they did anything wrong in handling the situation. What I want to know is what happened after she consumed the peanut. Because it said that she was reported having like scratches and like bumps and stuff like that. Like, what did the teacher do? What did the school nurse do? Johnson's mother, Laura Mary Beth Pendleton, also schooled Chesterfield County Schools for defamation, claiming they implied she was to blame for the daughter's 2012 death. Pendleton, a licensed practical nurse, said she informed the school's daughter's severe allergy, provided them instruction and medicine should she have a reaction. Oh my God, that's so sad. But, I think it's working now. Yeah, this is the little girl right here. So sad. The family settled 2 lawsuits after a young Chesterfield girl died at school with peanut allergy. The mom said, "I'm angry. I don't know who to be angry at this point. My main concern is what happened after she was exposed." Pendleton filed a wrongful death suit against the school nurse and clinic aide, saying Amara had a known peanut allergy and medical plan established with the school. Because if you go back to the op-ed, let me see if I can find it real quick. Amber Heard, Washington Post op-ed. Oh, by the way, do you guys see the editor's note? So after the after the verdict, Washington Post put like a editor's note right there. 2 years ago, I became a public figure representing domestic A. I felt the full force of our culture's wrath for women who speaks out. And you know what happened 2 years ago? 2 years ago, she was married to Johnny Depp. That was when she had the TRO. So who else would the A word apply to? Who else would it apply to? The domestic A word. Obviously, Johnny Depp. And of course, they try to worm their way out of it by saying, well, actually, she did talk about, the college experience that she had about being harassed and stuff like that. And, at a very young age. But let's just see how the appeal goes through. Because like I said, there could be some loopholes that we don't know about. We don't know what kind of things her attorneys are going to pull out. But we'll just have to wait and see.